Hello, I'm David Wilson. I'm a solicitor advocate and partner at Digby Brown, and today I'm going to speak about a recent decision that has clarified the law with regards to the definition of immediate family who have the right to a claim for loss of society in terms of the Damages Scotland Act. Now, traditionally, the immediate family, when the Act was first passed, was just the nuclear family, married spouses, parents and children. Now, in 1982, it was extended to allow cohabitees. The passage of the Human Rights Act retrospectively extended the right to same-sex partners, and in 2006 new categories were created. In particular, siblings were allowed to claim grandparents, and also persons who had accepted the deceased as a child of the marriage. Now, this is where the problem occurred, because in terms of the Schedule 1 of the 76 Act as amended, they advised that no award, and this is under new subsection 4A, no award of damages under section 4 or above shall be made to a person related by affinity to the deceased. The idea behind this was to stop parents-in-law or children-in-law making a claim. However, if there was any doubt about the definition of a relationship of affinity, they attempted to clarify it by paragraph 4B, stating that it included a stepchild, step-parent, step-brother, or step-sister of the deceased. Now, this didn't make any sense because, of course, the new Schedule 1 made it very clear that persons who had accepted a child as a member of their family could claim, and suddenly they were saying that stepchildren or step-parents were specifically excluded. The matter was confused even more by paragraph 2 of the new Schedule 1 that said, any relationship by affinity shall be treated as a relationship by consanguinity. Any relationship of the half-blood shall be treated as a relationship of the whole blood, and the stepchild of the parent of the person shall be treated as his child. So the law really was not clear as to whether, in particular, step-parents were entitled to a claim. Now, this clearly wasn't the intention of Parliament, and as the Parliament attempted to adopt the recommendations of the Scottish Law Commission, which, in their report on title to sue for non-patrimonial loss, they made it very clear that the effect of the amendment would be to include those step-parents who in fact accept a child as a child of the family. Now, it was fairly standard for insurance companies and for defenders to reject claims of loss of society for step-parents. I have to say, having done quite a few of them, I never accepted this and always progressed them to a successful conclusion. Now, this clear anomaly in the law was addressed in the very recent case of Rosalind Michelot and others against Arthur Botterill and others, 2010 Court of Session cases 84, that was issued on the 6th of July 2010. This was a judgment by Lord Pentland. Now, in this case, the 8th pursuer was the stepfather of the deceased. Now, whilst he had not lived with the deceased until after the deceased was the age of 16, the evidence was clear that they had a very close relationship, and indeed the 8th pursuer had accepted the deceased as a child of the family. Now, the defenders in this case argued that in a strict interpretation of Schedule 1 as amended, he was in a relationship of affinity because he had been married to the deceased's mother and consequently did not have a claim. Now, Lord Pentland rejected the defender's argument on two grounds. Firstly, he invoked the golden rule of statutory interpretation set out by Lord Penrose in the case of Barrett Scotland Limited against Keith in 1993, Session Cases 142, where it says that the words of the statute must prima facie be given their natural and ordinary meaning in their context and according to the appropriate linguistic register without addition or subtraction, unless that meaning produces injustice, absurdity, anomaly or contradiction. And Lord Pentland in the case of Michelot said it clearly fell within that category of exception. Lord Pentland invoked the golden rule of statutory interpretation as set out by Lord Penrose in the case of Barrett Scotland Limited against Keith. in 1993, and that is you must give the natural and ordinary meaning, but you must put it into context. Unless the meaning produces injustice, absurdity, anomaly or contradiction, and clearly, according to the Lord Ordinary in the present case, the decision, the strict literal interpretation, or as Lord Pentland calls it, a slavish adherence to literalism, would give injustice, absurdity and contradiction, and consequently he interpreted section 1.4 as, when you read the legislation as a whole, he says it's to hold that the exclusion has effect only where there is nothing more than a relationship of affinity. Therefore, if a step-parent has not accepted a child into the family, then the exclusion applies. But where the step-parent has accepted the child into the family, the exclusion does not apply. Lord Pentland, interestingly, on the second ground, suggests that the pursuer would have been entitled to invoke his rights under Article 8 and 14 of the European Convention on Human Rights, right to family life, to override the strict literal interpretation of the Act. It is perhaps a surprise it's taken more than 4 years to come to this conclusion. Professor Norrie, in his article Rushed Law and Wrongful Death in the Journal in April 2006, pointed this anomaly out. However, if you have a case in which a step-parent is entitled to claim and you haven't done so, I'd recommend that you do so now, obviously barring issues of time bar. If you wish anything clarified, or if you wish an assistance in a case like this, please contact me. You can get me at email david.wilson@digbybrown.co.uk.